Anyway, so as I say, welcome to what is our final live insight session for now, looking at the changes of the Employment Rights Act, and in particular we're delving into trade union changes today. So myself and Karen are going to be chatting through that. We're not going to be going into a huge amount of detail in terms of some of the changes, because our focus today is going to be on the implications for you as employers, rather than necessarily the nuts and bolts of some of the detail that has changed. If you are interested in the nuts and bolts, you want to find out more, then please do feel free to contact either Karen or myself, or indeed one of the many professionals at Knights who you are likely to already be in contact with, and I'm sure that they would be delighted to hear from you. So, trade union changes under the Employment Rights Act. Now, there's been a number of changes, and actually the first change that came in under the Employment Rights Act was the repeal of the minimum service levels in terms of certain public sector services. Now, that was the first thing that came in on the 18th of December 2025, which just goes to show how important the trade union position is under the Employment Rights Act. So, other changes that are set out within the Employment Rights Act, and in particular looking to make, in our view, our shared view, and I think a very widely held view, is aimed at helping to make industrial action easier, and also helping in terms of trade union recognition and access. So a few things that have changed already. So the notice requirements for strikes, that has been reduced from 14 days to 10 days. So trade unions only need to give employers 10 days notice of strike action. Industrial action mandate, so where there is a positive ballot in favour of industrial action, that mandate remains valid for a period of 12 months now. So that's extended from 6 to 12. Also, removal of a 40% support threshold. So if there is a ballot, 40% of the threshold, 40% need to be in support of industrial action, and that's within important public services. Removal of picket supervisors, that requirement's been removed, and this is all alongside changes that are coming in or have come in, introducing the ability to e-ballot members. And also the removal of various thresholds, and we'll do a little bit more on that later. So as I say, ultimately what we are looking at here is a much easier framework in which for trade unions, members of trade unions to operate, and potentially meaning we are more likely to see strike action. Yeah. What do you think, Karen?
I think the summary you've given was excellent in terms of the ramifications for employers could be very significant, especially for those who aren't at the moment in the trade union climate. They're not used to dealing with trade unions. It's not part and parcel of work industrial relations, and there are many employers that don't have the connection with unions that really will be needed in order to understand fully what these mean. So we'll need to be looking as an employer at policies in place, contingency plans. You need to start thinking about what you would do in terms of industrial action, because all these changes making it so much easier to look at industrial action. So the climate's massively changed.
Yeah, absolutely.
It's going to be quite significant, I think.
Yeah, 100%. I think I mean, it is relatively infrequent that we come across employers where there is trade union recognition, mainly public sector, education, health, and so on and so forth. But the number of changes within the Employment Rights Act that are coming in, have come in already, certainly means that we are going to see much more involvement. And as you say, employers who are used to a non-union environment potentially are going to find themselves having to deal with, if that's the right expression. Certainly having more involvement with members, with representatives.
That's right.
And so on.
With longer running disputes as well, because you've got this change in terms of the mandate that you talked about, potentially lasting up to 12 months as opposed to previously 6. So you could have potentially longer running disputes, more disruption at work. So it is a good time now, if you haven't already started, to think about the risk assessment and what impact would that have on your business? How are you going to safeguard the viability of your business if it was taken hold of in industrial action in some shape or form? Because we'll talk a little bit later about how unions will become more relevant to employers who are not currently unionised, and don't have that regularity of dealings with unions. But this is a topic that is going to be relevant for most employers, I would have thought.
Yeah. I mean, we've seen recently, haven't we, that sort of the strike action within the health service, for example, on the transport sector as well, where, you know, unions are, I think we've had a period of calm, if I can put it like that, where we haven't quite seen the same union activity as perhaps we did 70s and 80s, and then, you know, kind of there was that period of calm. Now we've started to see it again. It's not to say necessarily we'll start to see wholesale strikes and so on and so forth across different sectors, but the risk is certainly more real, and I think preparation is going to be key.
Training of staff is going to be relevant as well, because if you're in an environment where you don't have a regularity of dealing with trade union representatives, then it would be good, I feel, for an employer to look at some degree of training in terms of how to make the most out of the relationships with trade union reps, because they are very important. They carry out a very important role, and as an employer, the good employers will want to foster that relationship to get the most out of it for the business, but also for the workers as well. So if you can see it in a positive light, I think that's the way to go. You have said this point about seeing the Employment Rights Act as a positive challenge, and I think that's a continuation of that, really.
Yeah, 100%. And I think, well, having worked with employers who do have trade union recognition, you know, a key thing is going to be building the relationships with those representatives, but also, even before the trade union sort of perhaps knocks on your door, more on that a little bit later, is actually thinking about how you're engaging with your staff as well. Because if you've got a really strong culture where your employees feel that they're listened to, they're appreciated, they're recognised in the sense of their contributions to the business, perhaps those individuals, I mean, I would say it stands to reason that those individuals are going to be less likely to be receptive to approaches from a trade union who is seeking to get a foothold. And it's, again, it stands to reason if you've got a disgruntled workforce or unsettled, not feeling listened to, not feeling appreciated, perhaps you're more likely, you know, that there is that foothold there for the union to get that lift.
Training is really important, because for many of us, dealing with unions and the issues that unions deal with on a regular basis is going to become a part and parcel of the working relationship of good industrial relations in a way in which it hasn't before, not for a long time. So that training is key, also at the human resources level, for the HR team to be ahead of this, to get ahead wherever they can in terms of planning what needs to be looked at, what the considerations are, because it's not necessarily common sense. I think there's quite a lot to this.
Yeah, absolutely. And the devil, as they say, is definitely going to be in the detail, and some of the detail is yet to be determined. But alongside the changes that are being introduced have been introduced actually under the Employment Rights Act, are stronger protections for individuals who are involved in trade union activity and industrial action. So one of the things that has been introduced is a stronger protection for unfair dismissal. So currently individuals have would be deemed to be automatically unfairly dismissed if they are dismissed in connection with industrial action, but that has been time limited in the sense that there is a 12-week period starting from day one of the action, and that period is actually has been
February,
has been removed. Sorry, getting my time frames mixed up. So ultimately, you think that 12-week window gave you a bookend to sort of go, okay, well, after that 12-week window, we can dismiss without having to think about it, in inverted commas. The removal of that 12-week window now means that an individual could be involved in strike action today, and actually 6 months' time, if my maths is correct, they could still be arguing that their dismissal in 6 months' time is related to the strike action. So as an employer, you've got to be thinking about and documenting. I'm a really big believer and a really big advocate for documentation, not least because, and it's even more important with the removal of the time, well, not the removal of the time limit, but the 6-month claim limit and so on, memories fade, etc., etc. You've got to document why you are taking particular action. And that's coupled with the introduction of protection against detriment. So dismissal, one protection, anything falling short of dismissal in terms of less favourable treatment or detriment, in the words of the Act, is going to have protection.
That's right.
As well.
We do need to mitigate that risk by taking steps to really look at disciplinary procedures, look at why you're not happy. If there's any connection whatsoever to trade union activity, you need to slow down. You need to understand whether or not you have reasonable grounds to progress because of this enhanced protection, because we've got automatic unfair dismissal now for union related activities without that 12-week window, as Julie was talking about. Employers do need to be very cautious. This is why we need some training in an area where many employers haven't needed to even think about this before. Whereas now you've got a whole new area of employment law potentially going to be directly relevant to employers for the reasons we'll come on to in a moment. So my view is that training, greater scrutiny of processes, training of managers too, but I think first and foremost HR professionals, so that they can take the lead as to what needs to be watched, because the managers will need some guidance and support, because if there's any connection to industrial action, it's quite likely you're not going to be able to do anything.
Well, there was a case recently where it drew the really important distinction between the fact that somebody was engaging in industrial action and how they were engaging in industrial action. And that's going to be a really, really important distinction. And I suspect, I mean, there is case law already, as I've just said. We're going to see, I suspect, that sort of thing increasing, particularly with the introduction of detriment protection. There will be that argument about whether or not the activity that, it is not beyond the realms that individuals will be dismissed or subject to disciplinary action because of an activity that they have engaged in whilst striking, rather than the simple fact that they've been striking. And actually it's important to bear in mind that the detriment extension, and indeed the dismissal extension, potentially extends to being involvement in a recognition process, sort of campaigning for or campaigning against recognition process. So there's a lot of things for employers, HR professionals, managers to be aware of, and an area that perhaps has not been the case and been on the radar so far.
Yeah, absolutely. Because I was looking into this, and it's quite clear that you can have an independent trade union that is discussing points, but they may not actually be formally recognised. That's a separate process from being an independent trade union and having a certification certificate of that. So the whole recognition process and a worker supporting the recognition of the trade union is protected, as is derecognition as well, which I thought was quite interesting. So any involvement of the worker in the recognition or derecognition of a trade union, you wouldn't be able to do anything about if you felt that that was impinging on the work that they were doing for you. You'd have to be very, very careful about that because of this enhanced protection, because the whole purpose of the reform seems to be increasing the activity of unions, increasing workers' rights as part of that union set up to encourage dialogue, to encourage active involvement and stop an employer from clamping down on that, which again is quite a new approach.
Yeah, I think it's supporting the employee voice within the within the workforce in that sense,
which is a good thing.
It absolutely is. It absolutely is. It absolutely
just a bit of a minefield to navigate.
And well, 100%. And I know through having dealt with employers and trade union, where there is trade union activity, there is a view that potentially individuals are so protected that there isn't an ability to do anything, even though it's unrelated entirely to trade union activity. And I think I'm certainly a very big advocate of that because somebody is involved in trade union activity, they're not, they can't be touched in any way, shape or form. But I think you just need to be a little bit more thoughtful, a little bit more careful, and document the situation. So Karen touched then, as indeed as have I, on the recognition process. So just a brief word about that before we go on to look at the rights of access by trade unions. So the recognition process is being simplified a lot. So we're going to change from a position of needing to have 10% of the bargaining unit within the trade union membership to a percentage of between 2 and 10%. So again, a shift. We don't know where it's going to land, but if you've got less trade union members in the bargaining unit, potentially you've still got the ability to seek recognition. There's going to be a removal of a need to evidence a potential majority in favour of recognition, and also a removal of 40% turnout requirement. So ultimately, what we're potentially moving to is trade union members of between 2 to 10% of the bargaining unit and a simple majority in favour of the recognition. So again, much more simplified process in terms of seeking recognition for the trade union. But I think one of the biggest shifts under the Employment Rights Act is the right of access, but alongside also a written statement that employers are going to have to send to employees to say you've got this ability to become a member of the trade union.
That's right.
That's going to be prescribed. We're expecting a form to be issued in terms of how it should look and what it should say. More on that as and when we get that
we're
detail.
Expecting it October, aren't we? I was looking into it as to what happens if we've already got the Section 1 statement of terms of employment already being provided, because the workers are already existing, and then you've got this new right coming in October 26 that they have to be given a statement of rights in terms of trade union rights that they have, and it will be a separate document, I understand, for those who already have the Section 1 statement. So you'll need to look at that as an employer. It's an important point that's changing come October time, and obviously for the new starters, it could potentially be incorporated within the Section 1 statement. We need to hear a bit more about the nitty-gritty, but in terms of those existing workers who are already there, who already have their Section 1 statement, it will be a separate additional document to provide.
And we are expecting that to have to be repeated. So it's not going to be a one-off start, and it's not going to be a one-off once this legislation kicks in, as we say, expecting it in October. There is expectation that that's going to have to be repeated, and I don't think we know the regularity of them.
No, we haven't got the detail just yet. Watch this space.
Watch this space.
You're updated. So then, connected to that, actually, I just wanted to mention the updated ACAS Code, which has been put to Parliament in relation to time off for trade union duties and what would be reasonable to be time off for trade union duties. There's quite important guidance in the code looking at the size and the resources of the employer, the operational requirements, the nature and scale of the representative's work and the needs of individuals. So there's quite a lot there in this code. We've also got, very interestingly, the right for trade union equality representatives to reasonable paid time off. This is a new provision that's coming under the Employment Rights Act 2025. So this requirement to allow reasonable time off for equality representatives from a trade union is a new aspect as well. So that's an interesting updated ACAS code, which again we're looking at seeing coming into force in October 26. So be mindful of that as well. Quite a lot, actually, interestingly enough, is coming in October.
Yeah.
It's a real hotspot, isn't it?
Yeah, so that's to do with the rights of access.
Rights of access,
yeah,
and reasonable time off in terms of the code for trade union duties. So then we move on to the access agreement. So this is a fundamental change, and for me is the most interesting aspect of the trade union reforms, because I feel it's going to have real massive ramifications for those employers who don't have dealings with trade unions at the moment. They just don't need to be involved in any way, shape or form. It's just not part of the work they do. The workers are not particularly interested in trade unions. It's not at all touched them in the way in which you have those unionised sectors who have, for years and years been dealing with unions, and it's not a big deal for them. Here we've got potentially a union coming along to an employer. They must have more than 21 employees. So those with less than 21 employees don't need to be concerned about this statutory process. But they're introducing in October 2026 a statutory right of access for recognised independent trade unions, and independent trade unions in this context means those who have a certification officer who's provided an independence recognition. So it's a certificate of independence that you need to check as an employer, and obviously those with less than 21 employees won't need to worry about that. But as long as the trade union has that certificate, they can reach out to the employer and say, we'd like access, physical access or digital access, and they would like access for the purposes of introducing themselves to the workers to see about signing the workers up to the union. It shouldn't be for the sole purpose of an industrial dispute. So it shouldn't be to arrange a strike. That shouldn't be the focus at all of this. And the code also helps clarify that. So that's not the purpose of this. But that's the inevitable consequence of it, really, because if they're getting in with their access agreement and want to introduce themselves, that's potentially where it may end up, not initially. What do you think?
Yeah, absolutely. And, trade unions tend to be recognised where they are recognised to collective bargain, so to discuss terms and conditions for the individuals within their bargaining unit that they're recognised for. But certainly, I think we are going to see, trade unions will inevitably be targeting employers where there isn't recognition already, potentially within certain sectors, potentially where there is known non-compliance, if I can put it like that, with certain regulatory requirements. So, as we've said, that these changes under the Employment Rights Act, so far as giving a greater voice to the trade unions, and indeed the employees through that, is going to be a massive sea change. And for you as employers, you need to be thinking about how you might handle that request for access. So where is that request going to go if it's received by someone else? How's it going to be recognised? who's ultimately going to take charge of that the right of access request. Ideally, you need to be thinking about this now, if you haven't already.
Read the code.
Read the code, first of all. Think about, okay, what in an ideal world would we like to give to the trade union who's asking for access? What can we accommodate? What can't we accommodate? What restrictions do we have to our workplace? Do visitors need DBS checks? What are the security arrangements? What confidentiality arrangements are there? What are the physical situations, the physical space we've got? What emails, what e-access can we give? Plan it now. Think about what you would ideally want to agree, what you could accommodate if there's pushback, and have your own sort of template access agreement in place that when this request comes in, you can send it out, and then you can deal with it.
Get ahead of it.
Get ahead
you said
of it.
Before.
Absolutely.
Because the emphasis in the code is on voluntary agreements. So initially, really, there should be a real effort on the part of both the union who's reaching out to the employer and the employer in response to try and voluntarily agree. And that would be the preferable route, so that you avoid that statutory access process, because that's a whole other ball game in terms of the forms that need to be used and the quite rigid process that needs to be followed. If you can get ahead of it, like you said, Julie, and really come to an agreement which works for you, and that you can have an amicable relationship with the union, and that's going to be preferable.
And there are some significant penalties, aren't there?
There are huge penalties. So if they go down the statutory process because the voluntary aspect hasn't worked, although interestingly, you don't have to try a voluntary agreement first, but I wonder how it will look to the Central Arbitration Committee that would ultimately be deciding whether or not to enforce a statutory right of access if there had been no attempt whatsoever on the voluntary side. So I personally think it's going to be frowned upon, but they do say that it's not an absolute prerequisite to try voluntarily, but it makes sense really to try. But if not, you go down a formal process of making a formal application to have access by the trade union on a specific form. There's a specific time then for the employer to respond, again on a prescribed form. If they can't come to an agreement, a referral can be made to the Central Arbitration Committee, which ultimately decides whether or not there should be an access agreement in place. They would look at whether there's already an access agreement with another union in place, things like that. But if you have an access agreement through the statutory process and it's not abided by, that's where the financial penalties can kick in, which are significant. So we've got up to £75,000 for a first penalty, up to £150,000 for a second penalty, and up to £500,000 for the third breach and subsequent non-compliance with the same access agreement, which is extraordinary.
Yeah, I mean, it is significant, isn't it? It is significant. So if you are in a union recognition situation, if you're not union recognised, if you want to find out more about what we've touched upon, and this literally is just a touch on, it's a highlights, it's a headlines, then please do get in touch with either Karen or myself, or as I said earlier, one of the professionals across Knights who would be very happy to assist. And of course, down the road, if you do get recognition, if you're in the recognition process, if you're getting a request for access, we'd be delighted to help you. Now, as I say, this is the final live insight session for this round, certainly looking at the Employment Rights Act and the implications. But we do have colleagues across the business who are delivering live insight sessions also. So Hannah Livesley is delivering a live insight session on the 18th of August at 11 a.m. Along with Zoe Rose, and that is covering cohabitation consultation. And there have been previous live insight sessions looking at inheritance tax and much more. So please do follow Knights on LinkedIn, follow myself and Karen for more on the Employment Rights Act, etc., as we come through. If you do have topics you'd like to hear about, whether it's within the employment area or others, then please do let us know. We may well be looking at 0 hours and fire 0 hours and fire and rehire in due course once we know more. And of course, just to drop this in there, we do have a change at number 10 Downing Street, whatever that might look like. And of course, that may impact on what we've been talking about today and indeed in the past. So as I say, stay tuned, follow Knight on LinkedIn for more on live insights and beyond. And we look forward to meeting you all or seeing you again at a future event. Thank you.
Thank you. Bye-bye.